Medical records are the most important documents in a clinical negligence claim, as they will be the basis of expert opinion that will determine the outcome of the claim. In order to be successful in a claim for clinical negligence, the first step is to prove breach of duty and causation. This means that you must prove that the treatment you received was substandard and that you have suffered injury and loss as a result. Together, breach of duty and causation make liability. This is achieved by an independent medical expert review of your medical records. The expert will need to consider whether the treatment you received was substandard or whether a reasonable body of like experts would have provided you with the same care. Further, if your claim is successful, then the amount of compensation awarded is largely based upon the seriousness of the injuries that you have suffered. In order to assess the extent of the injuries and any future treatment needed, the medical expert will perform an assessment. That assessment will be based upon their examination of you as well as any relevant medical history documented in your medical records. Medical records contain information from almost all consultations you have had with healthcare professionals. The information they contain usually includes why you saw a health professional, the details of their clinical findings and diagnosis, any options for care and treatment the health professional discussed with you, the decisions made about your care and treatment, including evidence that this care and treatment was agreed, and details of the action health professionals have taken and the outcomes. Medical records are not restricted to paper or writing, but can be anything upon which information is recorded, so can include documents such as X-rays, MRI scans, videos, audio tapes and discs. During the claims process, your records may be passed to a number of people, including any experts instructed, the person you are making a claim against, such as a hospital or GP and their solicitors, the insurance company for the person you are making a claim against, any insurance company or other organisation paying your legal costs, and any other person or company officially involved with the claim. You do not have to give permission for your health records to be released, but if you don't, the court may not let the claim go ahead, as the fundamental purpose of disclosing the records is to make sure that all parties are on equal footing, which simply means disclosing documents that are not only assist, but that may also damage the prosecution or defence of a claim. You can access your medical records without bringing a claim under the Data Protection Act 1998. You should submit your request for records in writing, and records will be disclosed within 40 days of receipt of the fee or request. The fee for disclosure of medical records under the Data Protection Act is to a maximum of £50. If a person has died, then you can access their records as the personal representative of the deceased under the Access to Health Records Act 1990. Again, there is a fee payable, but in this instance there is no set maximum limit.